Yeah.
Mind, close my mind, but I think we should put in the document first. You know why this? Why I think it's important because if it is the way Lashma came to us,
Kí lẹ wá ṣe?
Which one?
everybody. Good morning, everybody. Good morning, everybody.
That's 15, right?
Okay. Good morning, everybody.
Good morning, my lord.
Good morning, everybody.
Good morning.
Who am I speaking with?
Good morning, sir.
Good morning, sir.
Okay. Answer to the parties, especially. I want to see your faces.
Good morning, my lord.
Good morning. Good morning. Mr. Olayinka Mohammed, right? Who are you for? Who are you for?
I'm with Mr. Muftau
For the defendant.
Okay, where is Mr. Muftau?
I'm here, my lord.
Okay.
How will you be saying that I
really need to see this. Now I need to see Muftau and the claimant council. Muftau and the okay. Okay. Who is Susan? Susan, who are you standing for?
Susan is also for the defendant, my lord.
For the defendant, right?
Yes, my lord. And Irene Momo.
Okay, so there you are four.
Yes, my lord.
Yes, the claimant council. No. We are waiting for the claimant council.
Yes, my lord.
We are waiting. Please, as soon as she comes in, let me know. Have you called the council?
He said the network is issue. We're trying to join. Network is issue.
Huh?
They say network is issue. They're trying to join.
You can join by audio. You should hurry up. We have a long way to go, please. Because
They're trying to join. The network is issue. They're trying to join.
you can join. Can somebody go and call them outside?
He did. He's just coming back and calling. He said it's not official.
But are they aware that the matter is starting by 12?
Yes, they are. One person, that's Queen, said she's having network issues.
Mr. Muftau.
Epia.
Hmm?
Epia. Queen Epia.
Mr. Muftau.
Yes, my lord.
I learned Epia is aware she's trying to connect, but her network is giving her issues.
May I suggest that the court should commence and she will join us. We can't continue to wait for her.
Okay.
Yes, my lord.
Okay. Thank you.
Uh-huh.
I learned she's connected. Check.
Good morning. Good morning, my lord. I'm so sorry. I had serious network issues. I had to join with my phone. I couldn't connect to my laptop.
Where are
I'm
you?
very sorry. I'm in the office.
I use my phone. Yes, I use my phone. I don't use a laptop myself because
Even-
the laptop
even-
gives
even-
me issues.
Even here too, we are using our phones. I don't know why that should be an issue.
Okay, come on. So let me see their faces. So we can start. Call the case. Proceed now.
Resumed today, Thursday, 10th June 2021, before His Lordship, Honorable Justice F.I. Kola Olalere, presiding judge, via Zoom. Case number 1, suit number NIPN/YEN/338/2016 between Joseph Inyang and 1, Martin Grayhead. 2, Becker Hughes Incorporated. 3, Becker Hughes Company Limited.
Appearances. Are the parties in court? Are the parties present, please?
The parties are absent. My lord.
Yes, counsel.
Respectfully, my lord. Q.O. Epia. Q.O. Epia. My humble appearance is for the claimant in this suit.
Recording in progress.
Yes.
With utmost respect to the court, Ismail O. Mukhtar, appearing with me are my learned friends, A.O. Mohammed, I. Momo, Miss, and Susan Akindele, Miss. You humbly appear for the defendant.
Court's judgment. As usual, I'm going to read the reliefs as endorsed, the issues as framed by counsel to the parties, and then I'll go to decision part. I'm leaving out the summary of the pleadings and the summary of counsel's argument, but they are in the judgment. When you pick your copies, you see them there. Are we good with that?
As court pleases.
Okay. Okay. Court judgment. On November 15, 2016, the claimant sued the defendant, and by his amended complaint, together with his amended statement of fact, filed on January 22, 2020, at pages 702 to 740 of the record, is seeking for the following relief. 1, a declaration that the action of the defendant in terminating the claimant's contract of employment with the defendant by a summary dismissal letter dated 22/2/2016, entitled Notification of Redundancy, is unlawful, wrongful, a breach of the contract of employment between the claimant and the defendant, and a violation of Labor Act, Cap L1, Laws of the Federation of Nigeria, 2004. 2, an order of court setting aside the summary dismissal letter dated 29/2/2016, titled Notification of Redundancy, issued to the claimant by the defendant for being illegal, a violation of the contract of employment between the claimant and the defendant, and a violation of Labor Law Act, Cap L1, Laws of the Federation of Nigeria, 2004. 3, the sum of 9,448,004 naira and 6 kobo, only being the total amount due to the claimant from the defendant's voluntary release program and the redundancy package applicable in the defendant West Africa Geo Market, for pre-interest of 25% per annum from 29/2/2016 till judgment, and post-judgment interest of 25% till the payment of the said sum. 5, the sum of US USD $2,600 only, being the 1 year medical contribution due to the claimant from the defendant's voluntary release program policy in the defendant's West African jail market. 6, prejudgment interest of 25% per annum on the $2,600 to judgment, and post-judgment interest of 25% per annum from date of judgment till the payment of the said sum. 7, the sum of 1 million naira being cost of this suit. And 8, an order of perpetual injunction restraining the defendants, whether by themselves, their servants, workers, receivers, agents, or previous, from selling, divesting their interest, and transferring the second and third defendants to General Electric, or in any manner whatsoever interfering with or dissipating the second and third defendant assets for the purpose of denying the claimant the due redundancy package and voluntary release program. In the defendant's final written address, at page 782 of the record, their counsel raised 3 points of objection this way. 1, whether the claimant exhibit C1, C4, C5, C6, C8, and C11 are competent, relevant, and reliable documents that can be acted upon by this honorable court. 2, whether this honorable court has jurisdiction to entertain this suit in the first place, the claimant having failed to sue his employer as a proper party to the case. And 3, considering the fact that the claimant attempted to prove his case through a proxy witness, Enoch Harry, whether the claimant witnessed testimony before the court amounted to a hearsay evidence and therefore not admissible before the court. After arguing those objections, then counsel to the defendant formulated 3 issues for determination of this court on its merit as follows. 1, considering the fact that Exhibit C2, that's the contract of employment, was between the claimant and BJ Services Company Nigeria Limited, a party which was not sued in this case, and the nature of the evidence already adduced before the court. What? Before the court, whether the claimant's claim against the defendant ought to be dismissed by this court. 2, having regard to the claimant's claims and the defendant's defense before this honorable court vis-a-vis the evidence led by the respective parties during trial, whether the claimant's claims are liable to be dismissed by this honorable court. In the alternative, that's number 3 now, whether the claimant's action is not cut off by the principle of estoppel, having accepted payment of his terminal and redundancy benefits from his employer BJ Services Company Limited in full and final settlement of his entitlement arising from the termination of his employment. At page 854 of the record is the final written address of counsel to the claimant, in which he formulated the following issues for determination of this court. 1, whether the defendants violated the provisions of the Labor Act and International Labour Organization Convention Protocol in declaring the claimant redundant in the course of their contract of employment. And 2, whether the claimant is entitled to redundancy payment in accordance with the voluntary release program policy of the defendant's West African jail market. Then I now go to the decision part of the judgment. I have carefully gone through the facts of this case as pleaded and deposed to by parties. Their final written arguments, the final written arguments of their counsel, including their cited authorities, statutory and case laws. From all of this, I am of the considered view that the following issues need to be resolved by this court between the parties. 1, in respect of the objections of the defendant's counsel, this court will decide whether the claimant's exhibits C1, C4, C5, C6, C8, and C11 are competent, relevant, and reliable documents. It will also determine whether this court has jurisdiction to entertain this suit based on the parties before the court, and will also resolve whether the testimony of the claimant's witness before the court is hearsay evidence. 2, are the claimant's claims liable to be dismissed by this court for being caught up with the principle of estoppel? And 3, was the claimant's employment properly determined by declaring him redundant in line with the terms and conditions of his employment? The provisions of the Labor Act, and that of the International Labour Organization Convention Protocol. Is the claimant entitled to redundancy payments in accordance with the voluntary release program policy of the defendant, West Africa Joe Market, or at all? Before resolving this issue, it is to be noted that on July 10, 2019, when this matter came up before this court, lead counsel to the parties, that's Judge Ogara and YK Kadri, agreed that this matter with suit number NICN-YEN 338-2016 be used as test case for the following sister cases with suit numbers NICN-YEN 243, 247, 254, 256, 257, 259, 262, 263, 26. This 266. 266, 286, 296, 299, 225, and 426, 2016. And the court granted their request. See pages 3 to 5 of the court proceedings file. However, on November 12, 2019, the file with suit number NICN-YEN 266-2016 was brought before the court, and the claimant therein, Friday October, filed notice of discontinuance. See page 656 of the record on this case with suit number NICN-YEN 266-2016. The matter was accordingly discontinued and dismissed in line with Order 61 Rule 7 of the NICN Civil Procedure Rules 2017. As a result of its dismissal, NICN-YEN 266-2016 is no longer part of these Group B cases. Therefore, the remaining cases in this Group B, together with the instant suit, are NICN 243, 247, 254, 256, 257, 259, 262, 263, 268, 279, 282, 286, 296, 299, 22, and 225. Respectively. Now to the merit of the, to the judgment. Whether Exhibit C1, C4, C5, C6, C8, and C11 are competent, relevant, and reliable documents. On July 10, 2019, at pages 3 to 7 of the proceedings file, the claimant tendered 10 documents as exhibit in this case. Exhibit 1 is the bylaw of the second defendant. It is at page 498, pages 498 to 522 of the record. Exhibit C4 and C41 are West African Geomarket Organizational announcement dated 30/11/2015 and 5/12/2015 at pages 537 to 540 and 541 to 542 respectively. Exhibit C5 is the Baker Woods, Nigeria, West Africa, and Central African Geomarket Revenue and Profit Margin in 2015. It is at pages 543 and 544 of the record. Exhibit C6 is the VRP mandate, but described in the amended list of documents at page 495 of the record as Manager Arnold Ludovic Master and the Congo Agreement with Translation. See pages 545 to 546 of the record. Exhibit C6 is titled From Human Resources Subject, Update on Nigerian Town Hall Meeting 1. See page 548 of the record. The defendant contended that Exhibit C11 in this case is the power of attorney that the claimant issued to CW1, allowing CW1 to prosecute this case for him. They prayed the court to discountenance this exhibit on ground that they are not competent, relevant, neither are they reliable. From the record of this court, there is no document marked as Exhibit C11. The power of attorney in question is at page 723 and 724 of the record. It is immediately after the amended statement of facts, and it is pleaded in paragraph 1A of the amended statement of fact filed on January 22, 2020. CW1 also deposed to it in paragraph 2 sub A of his written statement on oath at page 725 of the record. All these documents were pleaded in support of some facts averred to in this case. Therefore, all arguments of the defendant against the competence, relevance, and reliability of Exhibit C11 are hereby discountenanced as no exhibit is so numbered in the instant case. It is tried that where a document is relevant, its admission is proper, but the way to be attached to it by the court is a different thing. Once the evidence is probable to the fact in issue, it is relevant and therefore admissible. The rule of admissibility is different from the weight to attach to a document. See the case of Kahili versus Yibo, citation supplied. Because Exhibit C1, C4, C5, and C8 were presented in this case in support of certain pleaded facts relevant to them, I find that the exhibits are relevant to those facts. I further find that they were properly admitted to buttress those facts. It is tried that the duty of the claimant is to prove or establish his case with relevant evidence before the court, while it behoves on the court to determine the way to attach to the said evidence. On this call, I hold that Exhibit C1, C4, C5, and C8 are relevant and properly admitted in evidence for the determination of the claimant case before the court. I further hold that this court will determine the way to attach to each of them at the appropriate time in this judgment. Above holding notwithstanding, Exhibit C6 Exhibit 6, that's the one titled VRP mandate, was made on December 15, 2015. And by its content, the voluntary release program agreement and the entitlement stated therein apply to only employees of the defendant who chose to be released voluntarily from December 14 to 22 of 2015. From the content of Exhibit C7, titled Notice of Notification of Redundancy, the claimant, Ian Joseph, was declared redundant on Friday 29, 2016. In the circumstance, I find and hold that Exhibit C6 is neither relevant nor admissible in this case. I further hold that this exhibit was wrongly admitted in evidence and it is accordingly expunged from the court record. You are not answering me. Are you listening at all?
As the court pleases.
As the court pleases.
Does this court have jurisdiction to entertain this suit? It is the contention of the defendant that none of them is, sorry. It is the contention of the defendant's counsel. It is the contention of the defendant that none of them is the employer of the claimant. And so this court has no jurisdiction to entertain the suit as proper defendant is not before the court. The contract of employment of the claimant is Exhibit C2 in this case. It is at page 523 of the record. It is titled Contract of Employment between BJ Services Company, Nigeria Limited, the company, and Ian Joseph, the employee. The claimant's amended complaint and an amended statement of fact were filed on January 22, 2020. See page 702 to 722 of the record. The names of the defendants so filed and sued are Martin Drehead, Baker Hoods Incorporated, and 3 Baker Hoods Company Limited. BJ Services Company Nigeria Limited, same as those. Sorry, BJ Services Limited were not sued by the claimant as one of the defendants. The claimant sued the defendant as listed, like the initiating process he filed on November 15, 2016. In essence, the company that employed the claimant is not a party in the instant case, and I so find. Furthermore, on the letter of determination of the claimant's employment titled Notification of Redundancy, Exhibit C7, at page 547 of the record, one Ayobi Ishote signed for
I can't hear anything again.
Yeah, Ada.
BJ Services.
Wait.
The crux of this suit is.
My Lord, I think the network was off for like 10 seconds or so.
My Lord, I couldn't hear you in the last 30 seconds.
Yes, what did you hear last?
Shote. The name Shote, that's what I heard last.
That's what you heard last.
Yes, my Lord.
Yes, that's the one that signed for this. Where is that now? Where is Shote? Okay, can you remember the sentence?
Ayobi Shote. That maybe signed.
Ayobi Shote. Yes, Ayobi Shote signed. Okay. What of Opia?
My lord,
What did you hear now?
The last I heard was that the company that employed the claimant is not a party in this case, and I so find.
Okay, that's still the same program, paragraph. The crux of this suit is whether the claimant's employment was properly determined when he was declared redundant and whether he is entitled to redundancy benefits from the defendant under the VRP agreement. In the circumstance, I agree with the argument of counsel to the defendants that the defendants sued by the claimant in this suit are not proper or necessary parties. I find that failure of the claimant to join the right defendant, that's the claimant employer, BJ Services Company Nigeria Limited, is very fatal to his case. Consequently, I hold that the claimant's failure to sue his employer, BJ Services Company Nigeria Limited, totally robs this court of its jurisdiction to entertain this suit.
As the court
Did you hear
pleases.
that?
As the court pleases.
Okay. Is the testimony of the claimant witness hearsay evidence? CW1 in this case is one Enokari who gave evidence on behalf of the claimant on July 10, 2017. See again pages 5 to 7 of the proceedings file. On that day, CW1 adopted the written statement on oath he made on July 8, 2019, which is at pages 578 to 595 of the court record. Thereafter, and on January 22, 2020, the claimant amended his complaint and pleadings. He also gave CW1 power of attorney to prosecute the case on his behalf. The said power of attorney is at pages 723 to 724 of the court record. It is attached to the amended proceedings. On February 20, 2020, the claimant the court granted leave to the claimant's counsel as paid for to recall his witness CW1 so as to adopt his written statement on oath filed on January 22, 2020 in support of the claimant's amended processes, but counsel never did. See page 12 of the proceedings file. Based on this fact, counsel to the defendant contended that the evidence of CW1 is hearsay and that all the exhibits tendered through him by the claimant are hearsay documents, as no proper foundation was laid before putting them in evidence. In paragraph 1A of the amended statement of fact, the claimant pleaded issuing power of attorney dated January 15, 2018 in favor of CW1. However, the claimant did not tender same in evidence before the court, aside from attaching same to the amended statement of fact at page 723 of the record. As at the time CW1 adopted his written statement on oath at page 578 of the record, the claimant had not shown the court the power of attorney executed in favor of CW1. Furthermore, even though the power of attorney in question is dated January 15, 2018, it was only brought to the notice of this court on January 22, 2020, when the claimant amended his complaint and statement of fact. In the circumstance, I find that this CW1 did not disclose his source of information in respect of his depositions in his written statement on oath of July 8, 2019, in compliance with the provisions of Section 115 of the Evidence Act. Consequently, I find and hold that CW1 failed to comply with the provisions of Section 115 of the Evidence Act in making his said statement.
I'm sorry, my lord, we've lost you again.
And in adopting same on the in this case. Where did you stop hearing?
The past 5 seconds.
10 seconds ago, my lord.
That you hope 5 seconds ago that
tell me what you had last.
The claimant did not comply with section 115 of the
115 of the Evidence Act.
Okay. In the circumstance, I find that CW1 did not disclose its source of information in respect of its dispositions in its written statement on oath of July 8, 2019, in compliance with the provisions of section 115 of the Evidence Act. Consequently, I find and hold that CW1 failed to comply with the provisions of section 115 of the Evidence Act in making his said statement on oath and in adopting same on July 10, 2019 on behalf of the claimant in this case. As I have found above, the power of attorney in question was made on January 15, 2018 during the pendency of this case because the case was filed in this court on November 15, 2016. Consequently, I hold that the power of attorney was made contrary to the provisions of section 83 sub 3 of the Evidence Act. See also the case of Ugowe versus Chimokos Industry and Services Limited and another citation supplied. I further hold that the evidence of CW1 is hearsay evidence and it is not admissible in the instant case. The evidence is accordingly rejected in this. The above holding notwithstanding, the defendant joined issues with the claimant on the merits of this case. It is therefore expedient of me to resolve the case on its merit as contended by both parties. This leads me to decide on whether the claimant is stopped from making his claim against the defendant. The argument of the defendant on this issue is that when the claimant's employment was declared redundant, he was paid his terminal benefit according to his terms of employment. They went on that the claimant accepted the payment as full and final settlement of his benefit for the determination thereof. Therefore, he is stopped from making all these claims before this court. In this case, it is to be noted that the doctrine of first to pay is an equitable remedy, and it is tried that any person wishing to plead it must come to equity with clear hand. See the Participant Properties Limited versus Mr. Demola Fashola and others. And he who wants equity must do equity. See also Nemasa and another versus Hemsor Nigeria Limited. The contract of employment between the parties is a product of the terms and conditions agreed upon by them, and the parties are bound by the said terms and conditions they freely entered into. The question is, have the defendant come with clear hand to equity in the instant case? In other words, were the determination of the contract of employment and the payment of his terminal benefit fair, just, and in accordance with the terms and conditions of our employment? The letter of determination of the claimant's employment is at page 547 of the record. It is titled Notice of Redundancy, and it is Exhibit C7 in this case. It suffices to state here that determining the claimant's employment by declaring it redundant is not provided for in its terms and conditions of employment with the defendant, which is Exhibit C2. And I so find. Furthermore, by determining the claimant's employment contrary to the terms and conditions of our employment, I find that the defendant have not come to equity with clean hands. Consequently, I hold that the defendant cannot plead equity before this court, as they have not come to equity, as they have not done equity in the instant case.
As the court pleases.
Did you hear? See, please, I'd like you to be answering me. That will show me that you are listening and you are following.
As the court pleases.
As the court pleases.
Okay. Was the claimant's employment determined in line with the terms and conditions of our employment? Exhibit C7 is the letter with which the claimant's employment was determined by his lawyer, by his employer, BJ Services Company Nigeria Limited. It is at page 547 of the record. The exhibit is dated February 29, 2016, and it is titled Notice of Redundancy. Paragraphs 1 and 2 of this exhibit states, and I quote, BJ Services Nigeria Limited, the company, regrets to inform you that your employment has been declared redundant through no fault of your own, as you have been informed by your superior. The redundancy is due to a downturn in the business activities which significantly impact on the company. Your redundancy is effective Monday, February 29, 2016. You will be entitled to full terminal benefit as stated in your employment agreement. Please note that the company will pay you 1 month basic salary in lieu of notice. You are required to leave all company belongings in your possession with your immediate supervisor prior to picking up the full and final benefit checks from the HR department in Port Harcourt. End of quotation. By agreement of the parties as stated in clauses 3.4 and 3.5 of Exhibit C2 and D1, excuse me. I'm drinking water. It's not tea. It's just that it's warm water.
As the court pleases.
As the court pleases.
The employment of the claimant can be put to an end by his employer either by termination or by retirement only. See pages 531 and 532 of the record. It is the law that where parties have reduced the terms and conditions of service into an agreement, the condition must be observed as they are bound by that contract, which they freely entered into. Therefore, I find that determining the employment of the claimant by redundancy through Exhibit C7 is not provided for in the terms and conditions of the contract between the parties. In the circumstance, I hold that the determination of the claimant's employment was wrongful. You didn't hear me or what?
As the court pleases.
As
Sorry,
the court pleases.
I was muted. As the court pleases.
Okay. Was the determination of the claimant's employment in compliance with the provisions of the Labor Act and those of the International Labour Organization Convention Protocol? The claimant answered this question in the negative. He maintained that the mode of the determination of his employment by redundancy is not in compliance with the provisions of the Labor Act and the International Labour Organization Convention Protocol. On the other hand, it is the defendant's contention that even though the term redundancy was used in the notice issued to the claimant in ending his employment, the defendant only terminated his employment in line with the employment contract. They continue that the procedure laid down in the Labor Act on redundancy does not apply to the termination of the claimant's employment, as same was not provided for in the contract of employment. Moreover, the defendant went on that their management and supervisor or human resources manager had a meeting with the claimant during which he was informed about his termination, and that after then his terminal benefits were agreed upon and duly paid to him, which is signed for, accepting same as his final benefit. In clause 5.1 of Exhibit C2 and D1, parties agree that their contract will be governed by and construed in accordance with the laws of the Federal Republic of Nigeria. The Labor Act is a law in Nigeria, and so I hold that the provisions of this act is applicable to the claimant's contract. Section 20 of this act states, and I quote, that's section 20 sub 1. In event of redundancy, A, the employer shall inform the trade union or workers' representative concerned of the reasons for and the extent of the anticipated redundancy. B, the principle of last in, first out shall be adopted in the discharge of the particular category of workers affected, subject to all factors of relative merit, including skill, ability, reliability. And then C, the employee shall use his best endeavor to negotiate redundancy payments to any discharged worker who are not protected by regulation made under subsection 2 of this section. Subsection 2 of this section states, and I quote, the minister may make regulations providing generally or in particular case for the compulsory payment of redundancy allowances on the termination of a worker of workers' employment because of a worker's employment because of its redundancy. And subsection 3 states that in this section, redundancy means an involuntary and permanent loss of employment caused by an excess of manpower. End of quotation. Also, section 254C2 of the Third Alteration Act 2010 to the Constitution of the Federal Republic of Nigeria 1999 is another law of Nigeria that is applicable to this case. It provides that this court has jurisdiction and power to deal with any matter connected with or pertaining to the application of any international convention, treaty, or protocol which Nigeria has ratified relating to labor, employment, workplace, industrial relation, or matter connected therewith. See again the cases of Aloysius versus Diamond Bank PLC, Duru versus Sky Bank PLC, and Ilugbedu versus Sky Bank PLC. All citations are supplied. Exhibit C9 is a copy of Article 14 under the Termination of Employment Convention 1982, number 158. It is at pages 549 to 554 of the record. The article provides, and I read, and I quote, when the employer contemplates termination for reasons of an economic, technological, structural, or similar nature, he shall notify, in accordance with the national law and practice, the competent authority thereof as early as possible, giving relevant information, including a written statement of the reasons for the termination, the number and categories of workers likely to be affected, and the period over which the termination are intended to be carried out. See page 552 of the court record. That's end of quotation now. Even though this convention has not been ratified, this court is still enjoined to be guided by it in making decisions on similar issues. Besides, the reproduced content of Article 14 has been codified in Nigerian law as stated in Section 20 of the Labour Act, as quoted above. In the circumstance, I hold that the provisions of Section 20 of the Labour Act, and by extension, that of Article 14 of the Termination of Employment Convention, Exhibit C9, are applicable to the instant case. The essence of these provisions is to ensure that when an employee is to lose his or her job due to no fault of his or hers, but for employer's economic etc. reasons, the employer must inform its employee or employees through his or her or their own union or representative of the reasons for and the extent of the redundancy ahead of the determination of employment by redundancy. The employer must also negotiate adequate payment for the redundancy with their union or representative for the loss of their job, which is due to no fault of his or hers or theirs, and I so find. However, in spite of the clear and unambiguous content of the letter of determination of the claimant employment Exhibit C7, titled Notice of Notification of Redundancy, the defendant still argued that it did not declare the claimant redundant, but only terminated his employment. This contention holds no waters in my considered view, as the content of Exhibit C7 is explicit, unequivocal, definite, and it speaks for itself. The defendant is neither allowed in law to change the express content of Exhibit C7 by oral evidence, nor by any other form of argument. See Section 128 of the Evidence Act 2011. In the circumstance, I hold that the claimant's employment was determined by redundancy and that the determination was wrong. I further hold that the determination of the claimant's employment by the defendant was done in violation of the provision of Section 20 of the Labour Act, Section 254C2 of the Constitution of the Federal Republic of Nigeria as amended, and the provisions of Article 16 and 14 of the International Labour Organization Convention Protocol. This is because the steps set out in those laws and protocols were not followed by the defendant.
As the court pleases.
Is the claimant entitled to redundancy payments in accordance with the voluntary release program policy of the defendant? I have resolved earlier in this judgment that the voluntary release program stated in Exhibit C6 before the court are neither relevant nor applicable to the claimant case, because the lifespan of this exhibit had expired before the claimant's employment was declared redundant. This is because Exhibit C6 was effective from December 14 to December 22, 2015, while the claimant employment was declared redundant on February 29, 2016. In the circumstance, I hold that the claimant is not entitled to the end of services benefits stated in Exhibit C6. Consequently, I hold that the third, fourth, fifth, and sixth reliefs of the claimant as endorsed on the amended complaint and in paragraph 55, sub 3, 4, 5, and 6 of the amended statement of facts at pages 703 to 704 and 720 to 721 of the record respectively, which were for the sum of 9,448,004 naira and 6 kobo, as total sum due to the claimant from the defendant under the VRP, pre and post judgment interest of 25% on the said sum, and then the sum of $2,600 only, being his 1 year medical contribution under the VRP, and the pre and post judgment interest of 25% per annum on the $2,600 are not claimable by the claimant. Neither are they grantable in this case. Therefore, these 4 claims are accordingly dismissed in this judgment.
As the court pleases.
Okay. Is the claimant entitled to redundancy benefit at all? According to the defendant, the claimant has been paid all that he was entitled to under the contract, and that he even acknowledged same as full and final settlement of our entitlement for the termination of our employment. I have heard above that the claimant's employment was determined by declaring him redundant and not by determination. There is no evidence before the court from the defendant to the fact that the company, that the claimant's employer, gave the claimant prior notice of the reason for and the extent of the redundancy. Neither did the company give any evidence that it negotiated what to pay to him for declaring him redundant with his union or representative. The payment being mentioned here is different from the one agreed to by the parties in their terms and conditions of employment of the contract of employment, particularly in clause 3.4D of Exhibit C2 and D1 for being terminated by the defendant. It is a compensation that accrues to the claimant for losing his job by redundancy due to no fault of his, as guaranteed in Section 21C of the Labor Act. In other words, the redundancy ought to have been a gradual process, starting with prior notice, that's notification of the reasons for and the extent of the exercise, and then negotiation of the compensation to be paid to the claimant by declaring him redundant. Nevertheless, the company declared him redundant and paid him terminal benefit same day, February 29, 2016, as if he was being dismissed for gross misconduct. See the content of Exhibit C7. I have held above that the company declared the claimant's employment redundant contrary to its terms and conditions of employment, contrary to the laws of the Federation of Nigeria, and that's Section 20 and Section 254C2 of the Constitution as amended, and also contrary to Article 14 of Termination of Employment Convention as incorporated into the laws of Nigeria. It is also to be noted that these violated provisions do not provide any remedy or sanction against the company, the employer, for the violation, notwithstanding the fact that the defendant paid the claimant terminal benefit for termination of our employment under clause 3.4D of Exhibit C2 and D1. I hold that fairness and justice of this case demands that the claimant be paid compensation for being declared redundant by his employer, contrary to the laws of Nigeria. However, since the claimant did not sue his employer, I hold that there is no proper defendant before the court to be directed to pay any compensation to the claimant in this case. Did you hear that
As the
or
court
not?
pleases. As the court
As the
pleases.
court pleases.
As the court pleases.
Sorry, my phone is almost discharging. Okay, I'm not charging it. Is the claimant entitled to the sum of 1 million cost of action? In relief 7 endorsed on the complaint, the claimant is seeking for the sum of 1 million from the defendant as his cost of this suit. However, he did not give any evidence on how he arrived at the figure or some circumstances are that the claimant of the court, in line with the provisions of Order 55, Rule 1 of the NIC and Civil Procedure Rules 2017, considering the age of the case. However, I decline ordering or directing payment of any cost because there is no proper defendant to pay this cost to the claimant. On the whole, I declare and hold as follows. I hold that Exhibit C1. Sorry, are you people hearing me?
Yes, my lord.
Yes, my lord.
Yes, my lord.
Mr. Mustau, can you hear me? Okay.
Yes, my lord. Yes, my lord.
On the whole, I declare and hold as follows. 1, I hold that Exhibit C1, C4, C5, and C8 are relevant and properly admitted in evidence in this case. 2, I hold that Exhibit C6, VRP mandate is neither relevant nor admissible as it is not applicable to the claimant case. It is accordingly expunged. Number 3, I hold that the claimant's failure to sue his employer, BJ Company Nigeria Limited, totally robs this court of its jurisdiction to entertain this suit. 4, I hold that the evidence of C1 is hearsay and it is not admissible in this case, and it is accordingly rejected in evidence in this judgment. 5, I hold that the defendant cannot plead equity, that's estoppel against the claimant before the court, as they did not do equity in this case. 6, I hereby declare that the determination of the claimant's employment by notification of redundancy is wrongful, as it was done contrary to the terms and conditions of his employment. 7, I again declare that the said determination was done in violation of the provisions of Section 20 of the Labour Act, Section 254C2 of the Constitution of the Federal Republic of Nigeria 1999 as amended, and Article 14 of the International Labour Organization Convention Protocol. 8, I hold that the claimant is not entitled to any service to the end of service benefits stated in Exhibit C6, that's VRP policy, as it is not applicable to his case. Nine, consequently, I hold that his third, fourth, fifth, and sixth reliefs for the sum of 9,448,004 naira and 6 kobo as redundancy benefits under the VRP, pre and post judgment interest of 25% on the said sum, the sum of $2,600 as his 1-year medical contribution under the VRP, and the pre and post judgment interest of 25% per annum on the said sum are not claimable by the claim. But in the time, I hold that the fairness and justice of this case demands that the claimant be paid compensation for being declared redundant by his employer, contrary to the laws of Nigeria. 11, however, there is no proper defendant to direct to pay the compensation in question to the claimant in this case. Therefore, this case is dismissed. I make no order as to cause, and I hold that this judgment abides in principle to all the 15 other sister cases in Group B. They are with suit number NICN YEN 343 347 254 256 257, 259, 262, 263, 268, 279, 282, 286, 296, 299, and 2216. Judgment is entered accordingly.
As the court pleases.
As the court pleases.
We're
Sorry,
grateful.
Okay.
Hello, can I go on? We're grateful
Can I
to the
bring to the
court.
notice? I'm sorry, I want to bring something to the notice of my lord. The BJ cases under this group, Enoch Group B, are just two, my lord. Joseph Ian 2338, which is the one we just you just pronounced judgment on, and 225. The rest of them, they are not BJ. They are not
Let
BJ
us
cases.
that's
They are
not correct.
different.
That's not correct.
Very true. I have my records.
And the court, we also have ours.
Hold on, counsel. I have all my judgment here. You know,
As
even
the court
though,
pleases.
just listen to me. Even though we are using this one as test case to all other 15 cases. See,
Yes,
can you see me? Can you see?
Yes, my lord.
Yes, my lord, you can see.
I'm ready to read each of them. I think about 3 of them they were employed by BJ services. And I
about 2
those
of them in this group. Yes, my lord.
There are more than 2.
Then the rest of them, in this group, under this
3.
group B, okay, 2 or 3 of them, my lord.
Yes,
my lord.
I know of 2 to 5.
My lord, we have an observation. Having pronounced the judgment of the court, the council does not, even the court no longer has any jurisdiction to entertain anything. The council is at liberty to obtain the records and then take appropriate steps. I don't know whether we are doing the postmortem of the judgment.
Just hold on. Mr. Muftau.
As the court please, my lord.
Mr. Muftau.
Yes, my lord. I can, my lord, I'm here.
I need to see Muftau's face now.
Yes, my lord, I'm using my video, my lord.
Huh? Where is my own? Sorry, I'm trying to set. Anyway, I think the face of one of your aides should go and let me see your face.
I'm here, my lord.
Okay, that's fine. Where is Apia?
My lord, I'm here.
Okay, good. Yes, I need the faces of the 2 of you. Now, Miss Apia.
Yes, my lord.
If you look, that's why I like putting dates and pages on my record. So that when you go on appeal or you carry the file, even without me being there, you will see the pages I refer to. You will see all what I said there. The day that you people, your lead counsel, agreed to group this group is there. And I mentioned it today. So then the cases they agreed that will be under this group are listed.
Yes, my lord.
Yes, my lord.
Good. Now, the record of each of the files are here. All the files are here. I wrote my judgment on the 15, on all the 16. It really saved my energy, but I did it. So in this judgment, I realized that 225 was by
yes,
BJ.
My lord. Yes, my lord.
225 by BJ. 33, this one that I just read. 338 by BJ. And just hold on, 338. But I'll read them. I have them here. I'll read them to you.
Maybe my lord can just read the holding part. Maybe the decision of the court.
I'll read
the last part.
I'll read you.
The last part.
The findings, yes, the findings and the holding part. They are not many.
You want to read all of them.
So you will see them. You will see them. There are about 3 of them there. That
yes,
their employer is by BJ. The other, I think the one that ought to be number 4, it was the 3rd defendant that dismissed that one. I mean, that declared him or her redundant or something like that. Do you understand? So that is it. Whatever you want to do with the judgment, I thank God that I think with effect from Monday now we start resuming. You can come and pick your copies. They are ready.
As the copy.
You understand?
As the court pleases, okay, as the court pleases, I just wanted to
As the
bring
court
to my
pleases.
notice that it's not
Tell me
totally,
what
it
is
can't
on
be
your
totally.
mind.
Okay, my lord, what is
Tell
on
me
my
what
mind is the fact that Joseph Iyan, the third defendant of Joseph Iyan, is BJ Services. And almost about 15 of them, the third defendant is Baker Hughes Nigeria Limited. So it's not the third defendant of most of them, except for two that I'm sure of. It's just the two of them that are BJ Services, that have BJ Services as third defendants. So if this
Okay,
judgment
just
is going to apply to all of them,
what I read, where is my judgment? Give me. The last paragraph I read there is that this judgment is you people that agreed. I didn't force this agreement on you people.
My
The
lord,
lead
that's why I
counsel
said
of both
earlier.
parties agreed.
my lord, we
My
agree,
lord,
but
which
there
was
are
why, my
some
lord, which was
there
why
are
I
some
noted earlier.
discrepancies in the cases.
There is
There are some
no
differences,
reason
like
for
BJ.
postmortem of the
Just
judgment.
hold on.
Please,
Hold
Mr.
Counsel
on.
can
Mufta, allow
obtain
me.
the
I'm
record.
talking, Mr. Mufta.
But
Please,
you are
I'm
wasting the
talking.
time of the
Mr.
court.
Mufta,
You
hold
have
on.
your own
Mr.
turn.
Mufta, hold on.
You
Mr.
have your
You're wasting
turn.
the
Mufta,
Let me
time of the
make my
court.
points
I'm
clear,
not
please.
writing.
You have made it already. Counsel.
It's not
Let's
for
move
you
on.
to
You have made
Mr.
it
decide, Mr.
already.
Mufta,
Mufta. I'm just trying to
Mr.
bring to the
Mufta,
attention of my lord.
My lord, let my lord speak now. Counsel,
yes,
please.
Mr. Mufta, just hold on. Let's listen to her. Yes, me, Epia.
Okay,
She has made her
my
point
lord,
already, my
Miss
lord.
yes,
Epia, I'm
we
listening.
agreed. Yes, we agreed that Joseph Iyan should be the test case, and the judgment and rulings in Joseph Iyan should abide in the rest of them under Enoch Group B. But my lord, it's not entirely the same parties that are in Joseph Iyan that are the same in the remaining cases. Joseph Iyan and Anthony Akoribo,
Can you
225.
just calm down? Let me read the other judgments. Listen, I'm ready to read the other judgment. They are ready. I'll read it to you.
Okay, my
My
lord,
lord, just
343
the holding
is next.
part.
I just want to be sure that it's not exactly the same judgment, because it's not going to be applicable to the rest of them that do not have BJ Services as third defendants. That's just the point I'm trying to make, my lord.
Mr. Epia, the
Epia, my
last
lord.
point I read out here is that Epia, Miss
Epia, my lord.
I said
Yes, my lord.
Epia.
Yes. Epia, my lord. EPIA.
Is that not what I said? Miss Epia.
Yes, my lord.
Epia.
Yes, my lord.
Miss
Yes,
Epia.
my lord.
Miss Epia, listen to the last one, the summary, my last summary here. I said,
okay.
I hope that this judgment abides in principle to all the 15 other cases in this group. Then I listed them out. Now I want to proceed to read them one by one. How this principle in this decision apply to the other cases. Are you ready to listen now? You are not ready. Ms.
Okay,
Ipia.
I understand, my lord. I understand, my lord. Thank you very much, my lord.
So what are you people's reaction to this one? Because I need to put it. Miss Ipia.
Okay, my lord has explained
Yes,
that it abides. My lord has explained to me that it abides in principle. So
don't be matter semantic now.
As the court pleases.
As the court pleases.
They are not appreciating the court or what?
No, my lord, I appreciate my lord. It's
yes,
only
that's
that
what I want you to say now at this point.
Okay. Thank you, my lord, for the well-considered judgment.
We are grateful to the court.
I'm sure that's what you are taught in law school, right? Either the judgment is in your favor or not. You still have to appreciate the court. Is that not what you are taught?
As the court pleases,
exactly,
yes, my lord.
Exactly.
Yes, my lord.
My lord, on behalf of the defendants, we are grateful for the erudition, for the well-delivered and well-considered judgment. I'm most grateful, my lord.
Call the next case. Carry this one from there. Mr. Muftau. Mr. Muftau.
Yes, my lord.
Where are you?
I'm here, my lord.
Running to. Okay.
My lord, I'm here.
Call the
I'm
next
here, my
case.
lord.
Yes, we want to do the next case.
Case number 2. Suit number NICN/YEN/343/2016 between Blessing Isungie and 1. Martin Greyhead, 2. Better Hughes Incorporated, 3. Better Hughes Company Limited.
Court judgment. On November 15, 2016, the claimant sued the defendant and by his amended complaint together with his amended statement of fact filed on January 22, 2020 at pages 610 to 630 of the court record. He is seeking for the following reliefs: a declaration that the action of the defendant in terminating the claimant's contract of employment with the defendant by summary dismissal letter dated 30/11/2015 entitled Notification of Redundancy is unlawful, wrongful, a breach of the contract of employment between the claimant and the defendant, and a violation of labor law cap L1 laws of the Federation of Nigeria 2004. 2. Another of court setting aside the summary dismissal letter dated 30/11/15 titled Notification of Redundancy issued to the claimant by the defendant for being illegal, a violation of the contract of employment between the claimant and the defendant, and a violation of the labor laws, Labor Act Cap L1 laws of the Federation of Nigeria 2004. 3. The sum of 7,382,365 naira 36 kobo only being the total amount due to the claimant from the defendant voluntary relief program and the redundancy package applicable in the defendant's West African Joe market. 4. Prejudgment interest of 25% per annum on the said sum of 3 million plus, and then post judgment interest. Also $2,600 US. Then the post and pre-judgment interest, the 1 million naira cost of the action and all the rest of them. I'm giving the list of documents as listed there. They filed their list of documents, amended list of documents. Now the findings, it's better you listen to these findings. The findings from going through the file of 3, 4, 3, 4 what now? 343. The claimant's contract of employment is at pages 448 to 461 and 586 to 599 of the record. The employer is Baker Woods Company Limited, that's the third defendant. See also page 463. And so, this witness has sued our employer. Number two, second finding, the manager, Amnon Ludovic Minster, and the Congo agreement with its translation is listed as number 7 on our amended list of documents. See pages 473 to 475 of the record. This document is the VRP mandate stating the end of service benefits that the claimant is relying on for her claims. For some of her claims. The document states the voluntary relief program of the defendant. The document states the voluntary relief program of the defendant from December 14 to December 22, 2014. A copy of the letter of determination of the claimant, of the employment of the claimant, titled Notification of Redundancy, listed as number 8 on our list of documents, is at page 476 of the record. On this letter, her employment was declared redundant with effect from November 30, 2015. Court decision: on the whole, I declare and hold and direct on the merits of this case as follows. 1, I hold that the claimant employer is the third defendant sued in this case. See a contract of employment at pages 448 to 461 and 586 to 599 and page 463 of the record. 2, I hold that the defendant cannot plead equity, that's estoped, against the claimant before this court, as they have not done equity in this case. 3, I hereby declare that the determination of the claimant's employment by notification of redundancy is wrongful, as it was done contrary to the terms and conditions of his employment. 4, I again declare that the said determination was done in violation of the provisions of Section 20 of the Labor Act, Section 254C2 of the Constitution of the Federal Republic of Nigeria 1999 as amended, and Article 14 of the International Labour Organization Convention Protocol. 5, I hold that the agreement in VRP mandate, that's the voluntary relief program of the defendant, was only effective from December 14 to 22 of 2015. Therefore, it is not applicable to the claimant's case. Consequently, I hold that her 3rd, 4th, 5th, and 6th reliefs for the sum of 7,382,365 naira 35 kobo as a redundancy benefit under the VRP, pre and post judgment interest on the said sum. Then the sum of $2,600 as his final medical contribution under the VRP, the pre and post judgment interest of 25% on the said sum are not claimable by the claimant, neither are they grantable in this case. These 4 claims are accordingly dismissed. Number 7, I hold that the fairness and justice of this case demands that the claimant be paid compensation for being declared redundant by employer contrary to the laws of the land of Nigeria. 8, I further hold that the claimant is entitled to be paid the sum of 400,000 naira only as compensation for being so wrongfully declared redundant by the 3rd defendant. I hereby direct the defendant, the 3rd defendant, to pay 400,000 naira redundancy compensation to the claimant. I direct the 3rd defendant to pay 200,000 naira costs to the claimant. I direct the 3rd defendant to pay the judgment sum totaling 600,000 naira to the claimant within 30 days from today, after which judgment sum will begin to attract annual interest of 10% until it is finally liquidated. For detailed reasoning of this judgment, see a copy of the judgment on the sister case with suit number NICN YEN 338-2016. judgment is entered accordingly.
As the court pleases. I'm very grateful, my lord, for the well-considered judgment.
As the court pleases, we are grateful for the judgment.
Okay.
My lord, we didn't
Just
hear,
hold on, please. You didn't hear what?
my lord, from the holding, because the court made a holding in the first case regarding the hearsay evidence of the CW1, because in this case as well, the claimant also proved this case by proxy. There was no holding regarding that, my lord.
No, apparently I think all these your objections apply to all the this thing,
Yes,
right?
my lord, because all
the cases
not all
under
of
this
them, my
Yes.
lord. That's not absolutely correct.
I just lifted the
all of them
yes,
proved by
I just
proxy.
lifted the one on the merit.
My lord, it's
My lord,
happened
Yes,
in
that's
the
not
first
entirely
case.
correct, my lord.
the judgment
There are
applies.
different arguments in the different
Hold on.
cases.
My lord, in the first case, in the final holding of the court specifically held that the claimant's evidence was hearsay. The same applies to the other cases under Group B, because all of them proved their case by proxy. So my own observation is that in this second one, as it was in the first case, there is no mention of that aspect. That's just the observation that I'm making. Since our issue on the merit is speaks also to the fact that the claimant proved his case by proxy, and to that extent, he had no case before the court.
The holding in the objection applies to, that's why I'm not repeating, because we have said whatever we did this one. Those ones that are different are the ones I'm repeating.
As the court
Do you
pleases.
understand?
Yes, my lord, but I'm just saying
Mr.
that in the
I can't see your face
lord,
now.
My lord, I'm sorry, my battery is running down, so I'm just trying to conserve it. That's why I went off
You
video.
better charge it and listen.
Yes, my lord, I'm
Charge it,
listening.
because everything is being recorded. Everything is being recorded. The main
Yes, my lord,
one, that's 338. The judgment and the principles, they apply to all the cases. So those ones that are different are the one I'm bringing out. I don't need to write full judgment on each of them.
As the
And
court
that's why I
pleases.
said the last one I said there is that for detailed reasoning of this judgment, see a copy of the sister, a copy of judgment on the sister case 2016. That's the main case.
As the court pleases.
My lord, we agree. We agree fully, what my lord has said. But my lord
You've made your point.
Hold on. My lord made a
You've made your
critical
point, Mr.
finding
Mufta.
on the fact that the evidence of the claimant was hearsay. My lord, it was a critical reasoning that the court made, and it also featured in the final findings and the holding.
Yes, sir.
We are just saying that.
Mr. Mufta.
Yes, my lord.
Mr. Mufta, can you hear me?
I can hear you, my lord.
Why I'm not repeating it here? Why I'm not repeating it here? Really, they are on your objections. The decision on the objections applies to everything, because you raised the same objection on all the 16 cases, right?
As the court pleases.
Well, even if I'm wrong now, there's nothing that I can do. I can't add it now.
As the court pleases. As the court pleases.
It's you that will first of all go to the court of appeal, that I'm amending my judgment. So I've read that my judgment. Whatever you think is the issue, go and correct it upstairs.
As the court pleases.
Yes, my lord. As the court pleases. That's good, my lord.
Next case.
Number 3 on the cost list. Suit number NICN/YEN/347/2016 between Lotom Baribo Kwe and 1 Martin Greyhead, 2 Becker Hughes Incorporated, 3 Becker Hughes Company Limited.
The issues as endorsed, the release as endorsed here. 1, a declaration that the action of the claimant of the defendant in terminating the claimant's contract of employment with the defendant by a summary dismissal letter dated 15/4/2016 and titled Notification of Redundancy is Unlawful, Wrongful, a breach of the contract of employment between the claimant and the defendant, and a violation of labor law and labor law of Nigeria. Another, of course, setting aside the summary dismissal letter dated 15/4/2016, titled Notification of Redundancy issued to the claimant by the defendant for being illegal, a violation of the contract of employment between the claimant and the defendant, and a violation of the Labor Act, laws of the Federation of Nigeria. 3, the sum of 10,364,364,364,16 naira only being the total amount due to the claimant from the defendant's voluntary relief program, and the redundancy package applicable to the defendant's West African Jew market. Pre and post judgment interest of 25% on the said sum, and then 2,600 naira dollars being the 1 year medical contribution due to the claimant from the defendant's voluntary relief program and policy in the defendant West African Jew market, and then the pre and post interest of 25%. Then the sum of 1 million naira cost, and then another of a perpetual injunction. I go to the finding and decision part. The claimant's contract of employment is at page 607 to 618 and 656 to 667 of the record. The claimant's employer is Baker Hughes Company Nigeria Limited. The claimant's employer is the third defendant sued before the court. The manager Arnold Ludovic Minster, and the Congo agreement with translation is listed as number 7 on a list of documents. This document is not front-loaded. The letter of determination of employment of the claimant titled notification of redundancy. Stop.
It's not stopped.
Okay. Sorry, can you hear me?
Yes, my lord, we can hear you.
Yes, my lord.
You can hear me?
Yes, my
Yes,
lord.
my lord.
Remove it. This one. What's this?
It's my picture, my lord. I mute my video and the audio as well.
No, I don't want to see this picture. Remove it. You can hear you, but remove this picture.
That's the one I registered my Zoom account.
Well, remove it. You don't use this one to do official work. Remove it.
Yes, I'm back live.
Number 4 finding, please. What's the last one you had? Claimant counsel.
Okay, the third one. The
Okay,
sorry,
that's
I
VRP.
yes, my lord.
It's not front loaded.
Yes, my lord.
Okay.
Yes, my lord.
Number four, the letter of okay. The letter of determination of employment of the claimant titled notification of redundancy is not listed as number, is listed as number 8 on his list of documents. And a copy of it is at page 619 of the record. On this letter, our employment was declared redundant with effect from April 15, 2016. This claimant is a he or a she? Letum Baribo Kwe.
It's a
Is
man.
it a he or a she?
Is a he.
It's a man?
Yes,
Okay.
ma'am.
Okay. Thank you.
Welcome.
Court's decision on the I declare hold and direct on the merit of this case as follows. I hold that the claimant employer is the third defendant sued. See the contract of employment at pages 607 to 618 and 656 to 667 of the record. 2, I hold that the defendant cannot plead equity, that's exculpate against the claimant because before this court, as they have not done equity in this case. 3, I hereby declare that the determination of the claimant employment by notification of redundancy is wrongful and it was done contrary to the terms of the contract of employment. 4, I again declare that the said determination was done in violation of the provisions of section 20 of the Labor Act, section 254C2 of the Constitution of the Federal Republic of Nigeria, and article 14 of the International Labour Organization Convention Protocol. 5, I hold that the agreement on VRP mandate, which is the voluntary relief program upon which the claimant based 4 of his relief is not before the court. Therefore, his claims cannot be verified. 6, consequently, I hold that his 3rd, 4th, 5th, and 6th reliefs for the sum of 10,364,364.16 as redundancy benefit under the VRP agreement. Pre and post judgment interest on the said sum the sum of $2,600 US, and then pre and post judgment on it, and not claimable and grantable by this court. These claims are accordingly dismissed in this judgment. I hold that fairness and justice of this case demands that the claimant be paid compensation for being declared redundant by his employer, the third defendant, contrary to the law of Nigeria. We further hold that the claimant is entitled to the sum of 400,000 naira as compensation for being so wrongly declared redundant. I hereby direct the third defendant to pay the sum of redundancy compensation to the claimant. I direct the third defendant to pay $200,000 cost to the claimant. Number 9, I direct that the third defendant is to pay the judgment sum totally 600,000 naira to the claimant within 30 days from today, after which the judgment sum will begin to attract annual interest of 10% until it is finally liquidated.
We are grateful
As the
for
court
the
pleases.
and the court pleases.
For details of this judgment, see a copy of the judgment on the sister case with suit number NICNYEN 338/2016.
As the court pleases. We are grateful for the judgment of the court.
My Lord, we're grateful for the judgment. Hey, my battery is low. No, my charger.
Initials, Mr. Mufta.
My Lord.
Your initials, I want to make small recording on the initial. Ismail, okay.
Ismail O. Muftar. Ismail O. Muftar. Should I mention the name of my colleagues on this judgment, my Lord?
No, just leave that one. I'm writing in longhand. Just to make it complete. Yes, next.
Number 4 on the first list. Suit number NICN/YEN/254 2016 between Chinda Lawrence and 1 Martin Grayhead, 2 Becker Hughes Incorporated, 3 Becker Hughes Company Limited.
The issues as endorsed are practically the same. Is the date of this, the date that the claimant's employment was determined here is 26/3/2015. And the amount, Can you hear me, please?
Yes, my lord.
Counsel, can you hear me?
As a copy.
Yes, my lord,
Yes,
you are
my
hearing, my
lord.
lord.
Okay.
Yes, my lord, I'm here.
Okay, instead of reading all that, I'm just bringing out the difference there. So the date that his employment was determined, Chinda is a man, right? Okay.
Yes, my lord.
The date his employment was determined was, okay. The date his employment was determined was 26/3/2015. The amount he's claiming is 10,934,681.84. And then practically the same thing, others. I think we are good with that.
Yes, my lord.
Then I go to findings now that is specific. Findings on his case. The claimant's contract of employment is at page 670 to 682 of the record. The claimant employer is Baker Woods Company Nigeria Limited. The claimant employer is the third defendant before the court. The VRP mandate is at the VRP mandate that is relying on is not front-loaded. That VRP mandate document is not front-loaded. The letter of determination of the claimant, the letter of determination of employment of the claimant, which is notification of this, is at page 668 of the record. And his employment was determined on March 26, 2015. The claimant did not list.
It says other material. When you write on what? It says any other material or other material.
What's that?
Is that a definition for other material? No. So
who is that? Mr. Muftau. Mr. Muftau.
My lord.
Is there any conference underground?
No, my lord. No, not at all, my lord.
Somebody is talking and interrupting my judgment. Okay, I could go to court's decision on this case. I hold that the claimant's employer is the third defendant sued in this case. I hold that the defendant cannot plead equity as estoppel. Number 3, I hereby declare that the determination of the claimant's employment by notification of redundancy is wrongful, as it was done contrary to the terms and conditions of his employment. I again declare that the said determination was done in violation of the provisions of the laws of Nigeria, and that's Article 14. I hold that the document, that's the VRP mandate, the voluntary relief program upon which he based 4 of his relief, is not before the court. Therefore, his claim cannot be verified. Consequently, I hold that the 3rd, 4th, 5th, and 6th relief of the claimant as endorsed are not grantable in this case. These claims are accordingly dismissed in this judgment. Now, number 7, I hold that The fairness and justice of this case demands that the claimant be paid compensation in form of general damages for being declared redundant by the defendants, contrary to the laws of Nigeria. I further hold that the claimant is to be paid the sum of 400,000 naira only compensation for being so wrongfully declared redundant. I direct the claimant, the third defendant, to pay the sum of 100,000 naira cost to the claimant. I direct the third defendant to pay the judgment sum, totaling 500,000 naira to the claimant within 30 days from today, after which it will begin to attract interest per annum of 10% until it is finally liquidated. For details ruling judgment, see a copy of the judgment on the sister case with suit number NICN YEN 338/2016. Judgment is entered accordingly.
As the court pleases.
As the court
We are
pleases.
grateful to the court for the well-considered judgment.
My Lord, we are grateful for the judgment.
When it's like this, don't write here again. You go to the next page. Yes, next file. Next file.
Number 5 on the cost list. Suit number NICN/YEN/256/2016 between Chima Chibueze and 1 Martin Grayhead, 2 Becker Hughes Incorporated, 3 Becker Hughes Company Limited.
What's the suit number?
YEN 256 2016, madam.
Cost judgment. The date of determination of this one is 15th March 2016. And she's claiming, he or she now? It's a he. Okay. He's claiming the sum of 26,937 naira 591. Sorry, 26,937,591 naira 96 kobo. And that's the difference there. Then the findings, the claimant's contract of employment is at page 161 of the 161 to 168 of the record. It has neither an address, addressee nor an addressor, no signature page. However, its letter of employment verification is at page 471 of the record, and it states that our employment was with the third defendant from July 25, 2008 to March 15, 2016. The VRP mandate that they are majorly breaking their claim on is at page 480 to 482 of the court record. The letter of determination of employment of the claimant is at page 485 of the record. And on this letter, his employment was determined on 15th March 2016 by the third defendant. Court decision on the whole, I declare hold and direct on the merits of this case as follows. I hold that the claimant employer is the third defendant sued. I hold that the defendant cannot be the estoppel. I hereby declare that the determination of the claimant employment by notification of redundancy as it was done. I declare that the determination of the claimant employment by redundancy is wrongful. As it was done in violation of the provision of Section 20 of the Labor Act, Section 254C2 of the Constitution, and Article 14 of the International Labour Organization Convention Protocol. Number 4, I hold that the agreement of VRP mandates upon which he based 4 of his relief is not relevant to our claims because our employment was determined on March 15, 2016, whereas the agreement in question was effective from December 14 to 22, 2015. It means that the agreement was no longer enforceable when the claimant employment was determined. Consequently, all the 4 reliefs there are dismissed based on it. Number 6, I hold that the fairness and justice of this case demands that the claimant be paid compensation in form of general damages to be declared redundant for being declared redundant by the third defendant, contrary to the laws of Nigeria. Number 7, I further hold that the claimant is entitled to the sum of 400,000 naira only as compensation for being so declared redundant. I hereby direct the third defendant to pay to the claimant the sum of 400,000 naira only compensation for being so declared redundant. I hereby direct the third defendant to pay 100,000 naira cost to the claimant.
As the court pleases.
Number 10, I direct that the
Yeah,
total totaling 500,000 naira to the claimant within 30 days is liquidated.
As the court
For this reasoning of this judgment, see a copy of the judgment of the court in the sister case with suit number NICN YEN 338 2016.
We are
As a
grateful to the court
As a court
for
case.
the well-delivered judgment.
My
and for
Lord,
the
we are
end
grateful. My Lord, we are grateful for the judgment.
Tell them to put on the gen. Tell them to put on the gen. Where is the next file?
Can I proceed?
Counsel. Hello, counsel.
Yes, my Lord, we're here.
They
Madam,
just took my light. They are trying to put on the gen.
Yes,
my
we can
Lord,
see
as the
that,
court
my
please.
Lord.
Okay. No, I'll proceed. 2, 3, 4, 5. It's more than 10. It's 11. Yeah.
You take out one now, which is 10.
Tell him to give me my medicine. Yes, sir.
Yeah, 10. It's 217.
Hmm?
This is 217.
Okay, the afternoon. Ah. I can stand up before the light is on. My leg is aching.
As the court pleases.
Why are they not putting on the gen? Huh? Let them hurry up. Huh?
What are they diesel? Noisy. Then my lawyer is noisy for you to sit down. Just give me the 2 hours.
This coach is telling me to get up. What's the matter now?
And when you finish, bring it.
Open the agenda.
Tell them to put on the gym.
The security is not on. Let me call. See my registration picture. I don't know if they will be giving anything. Ismaili mustache. I hate old mustache.
You don't want that much to anybody. You don't want everything just go out.
To just go like that. There's when I get small thing.
As in, you're like, is in there. Almost argue, you know, you got that face. If you are nearly cry.
I get all the thing don't pay now.
My issue no be the one with the penny. Now the one where those mechanisms will be. They will prefer to appeal for this one night. They no go do
For them to pay compiling fee for this thing not today. For each of them. For each of them. They are going to pay like 100,000 for each of these things.
They pay for 100,000. They just go back. They said, this man just concerned me because they were ready to go this man. No something that get arguing and that way arguing.
That's what I'm buying another one sure. Yeah, people go to.
Like I said, all of them will do the same. They're not something. This case not we have to do something. No something that was arguing was serious man. That is Muftai. Now we didn't this.
It's a call of Muftai. Is it according to who mustache? And I named that. I own mustache.
Like 150K to 200,000 for each of them. They be volume 1 and 2.
They will select not all the documents. They will select.
Yeah, they will select the one, but there is no way. See,
don't want for obsession.
Wait, I don't understand. Select which documents.
No, they are not.
They will select another document. They select the one.
You won't do none of them. Just stand up and
Auditing now. How much is the money?
500,000.
Let them just pay more.
Let's before you calculate them.
For how many persons?
450. this
No,
one.
no, two or three, no, okay. Those
Let's just say for like,
BJs, maybe BJ.
let's just say for like 13 of them.
Blessing.
It's about
No, the first four now are 600 pounds. Only this one is 500.
all of them is about 5 point something million.
Only. They have the one of them.
Cancer. Cancer to the party. Mr.
Yes, my lord.
Apia. Okay, Mr. Muftau.
Yes, my lord.
Sorry, I just went to the restroom. I took the liberty of the light that was not off.
I forgot this.
Okay. So can we continue now?
Yes, my lord.
Which one the next?
Number 6 on the course list. Suit number NICN/YEN.
Have we done number 5?
Yes, my lord.
Okay, we have
Yes,
done.
my lord. Suit number NICN/YEN/257 2016 between Chima Ilo and 1 Martin Grayhair, 2 Becker Hughes Incorporated, 3 Becker Hughes Company Limited.
Okay. The date of determination of this one's employment is February 12, 2016. And is claiming 73,437,473.19 kobo. That's the difference in what is claiming. Then findings. The claimant contract of employment is at page 491, pages 491 to 503 of the record. On it, the claimant's employer is the third defendant before the court. The VIP mandate upon which they are basing most of their claims. I mean, 4 of our claims is at pages 523 to 524 the record. The letter of determination is at page 525 of the record. Okay, decision part now. I hold that the claimant's employer is the third defendant before the court. I hold that the defendant cannot plead estoppel. I declare that the determination of the claimant's employment is wrongful, as it was done contrary to the terms of his employment and in violation of the provisions of Section 20, Section 254C2 of the Constitution, Section 20 of the Labor Act, Section 254C2 of the Constitution as amended, and Article 14 of the International Labour Organization Convention. I hold that the agreement in VRP mandate upon which there is basing his 4 claims of the agreement in question, let's see, is not relevant to the claim because the employment was determined on February 12, 2016, whereas the agreement in question was effective from December 14 to 22, 2015 only. Means that the agreement was no longer enforceable when the claimant's employment was determined. Consequently, all the 4 claims, 3, 4, 5, 6, are dismissed. I hold that the fairness and justice of this case demands that the claimant be paid compensation in form of general damages for being declared redundant by the third defendant, contrary to the laws of Nigeria. I further hold that the claimant is entitled. What's the matter? Number 7, I further hold that the claimant is entitled to 400,000 naira compensation for being so wrongfully declared redundant. I hereby direct the third defendant to pay the 400,000 naira compensation to the claimant for being wrongly declared redundant. I direct the third defendant to pay 200,000 naira cost to the claimant. I direct the defendant to pay the 600,000 naira total as judgment debt to the claimant within 30 days from today, after which it begins to attract annual interest of 10% until it is finally settled. 11, for detailed copy of the sister case with suit number NICNYEN 338/2016.
As the court pleases. My lord, we are very grateful for the well-considered judgment.
We are grateful, my lord, for the well-considered judgment.
As the court pleases.
Yes, I need to make some entries into this into the proceedings file. Yes, next.
Number seven on the copy. Number NIC YAN/259/2016 between Daya Sawboy and one Martin Grayhead Becker Hughes Incorporated.
Becker Hughes
Three
Incorporated.
Becker Hughes Company Limited.
Becker Hughes Company Limited. This one's employment was determined on March 6, 2015. He's claiming 17,530,231 naira 87 kobo. And then all the others are 25% interest, this and that, blah, blah, blah. I go to the findings and decision part. The claimant contract of employment is at page 491 to pages 491 to 503. Only the claimant employer is the third defendant before the court. The VIP mandate is at page 523 to 522. Sorry. The VIP mandate is at pages 521 to 522 of the record. And then the notification, that's the letter of determination, is at page 661 of the record. And the date of determination is March 6, 2015. Decision, I hold that the claimant employer is the third defendant before the court. Hold that the defendant cannot plead equity, plead estoppel, that's equitable remedy. I declare that the determination of the claimant employment is wrongful, as it was done contrary to the terms of the employment and in violation of the provisions of the laws of the land. I also hold that the VRP mandate, upon which the claimant based 4 of his claims, is not relevant to this case, to these claims, because his employment was determined on February, on March 6, 2015, whereas the agreement in question was effective from December 14 to 22, 2015. It means that the agreement was no longer enforceable when excuse me, please. Give me that file. Where is the file? Where is the page now? Yeah, this page, this one I'm on. Check page 661 for me. What's the date here?
That's 6 March 2016.
6 months. Okay, the number 4 holding there, I hold that the VRP mandate agreement upon which the claimant based 4 of his claims is not relevant to this case. Because his employment was determined on March 6, 2016, whereas the agreement in question was effective from December 14 to December 22, 2015. It means that the agreement was no longer enforceable when the claimant employment was determined. Consequently, all the 4 claims are dismissed. I hold that the fairness and justice of this case demands that the claimant be paid compensation in form of damages for being declared redundant by the third defendant, contrary to the laws of Nigeria. I further hold that the claimant is entitled to 400,000 naira compensation for being so declared redundant by the third defendant. I hereby direct the third defendant to pay the sum of 400,000 naira compensation to the claimant for being so wrongly declared redundant. I direct the third defendant to pay 200,000 naira cost to the claimant for as cost of this case. I direct that the third defendant pays the judgment sum, totaling 600,000 naira within 30 days from today, after which the judgment sum will begin to attract annual interest of 10% until it is finally liquidated. For detailed reasoning of this judgment, see a copy of the court judgment on a sister case with suit number NICNYEN 338/2016.
As the court pleases.
As the court pleases, my lord, we are very grateful for the well-considered judgment.
My Lord, we are grateful for the judgment.
Next.
Number 8 on the cost list. Suit number NICN/YEN/262/2016 between claimant Ekpitan and 1 Martin Grayhair, 2 Becker Hughes Incorporated, 3 Becker Hughes Company Limited.
Employment 6/2015, and is claiming 3,116,001 naira 33 kobo. All the other claims are the same. Findings: the claimant did not file list of documents he is relying on. The claimant's contract of employment is at page 622 to 635. On it, the claimant employer is the third defendant before the court. The letter of determination is at page 6 3.6 of the record. And on it, his employment was determined on March 6, 2015 by the third defendant.
As a court.
On a court decision, I hold that the claimant employer is the third defendant before the court. 2, I hold that the defendant cannot plead exculpatory. 3, I declare that the determination of the claimant's employment is wrongful as it was done contrary to his terms of employment and in violation of the provisions of Section 20 of the Labor Act, Section 254C2 of the Constitution of the Federal Republic of Nigeria as amended, and Article 16 of the International Labour Organization Convention Protocols. I hold that the agreement in VRP mandate upon which the claimant based 4 of his claims is not before the court, and so there is no how the court could verify this claim. Consequently, I hold that all the 4 claims based on that VRP are dismissed. I hold that the fairness and justice of this case demands that the defendant be paid compensation in form of general damages for being declared redundant by the third defendant, contrary to the conditions of his employment and in violation of Nigerian laws. I hold that the claimant is entitled to 1,000 naira compensation for being so wrongfully declared redundant by the defendant. I hereby direct that I hold that the claimant is entitled to the sum of 200,000 naira, only compensation for being so declared redundant. I hereby direct that the third defendant pays to the claimant the sum of 200,000 naira as compensation.
Article, please.
Just hold on.
As a
I
court,
direct
please.
that the third defendant, just hold on, please. I hold that I direct the third defendant to pay the judgment sum of 200,000 naira to the claimant within 30 days from today. It begins, and after which it begins to attract interest. For details of this, for detailed reasoning of this judgment, see a copy of the judgment on the sister case, dispute number NICNYEND 338/2016. Judgment is entered accordingly. I make no order as to cost.
As the court pleases.
pleases.
We are most grateful, madam.
I know I'm grateful for the change.
Oh, okay. I've not done the entry. That one is 200. Okay. 5%. Reduce this AC, please.
It's at 24.
25. That's not 24.
You
Is
know,
that
because I pressed twice. Okay, yeah, I pressed, it didn't respond, so I went back and forwarded it.
Yes, next. Is that
Number 9 on the cost list.
262? I've done
263, ma.
Okay, I've done 262.
Yes, ma'am.
Okay. Yes, next.
Number 9 on the cost list. Suit number NICN/YEN/263 2016 between Emekunu Success and 1 Martin Grayhead, 2 Becker Hughes Incorporated, 3 Becker Hughes Company Limited.
Are you done?
Yes, madam.
Okay. The date of determination of this one is April 30, 2015. And he is claiming 3,302, sorry, he's claiming 3,302,441.43 naira 51 kobo. All other claims are the same. Findings. The claimant's amended list of documents is at page 443 to 444 of the record. The claimant's contract of employment is at page 475 to 488 of the record. On it, the claimant employer is the third defendant before the court. The letter of determination is at page 505 of the record. And then the VRP mandate is at pages 502 to 504 of the court record. Court decision, I hold that the claimant employer is the third defendant before the court. I hold that the defendant cannot plead estoppel. Declare that the determination of the claimant's employment is wrongful, as it was done contrary to his terms of employment and in violation of the provisions of the laws of Nigeria and Article 14. I hold that the agreement in VRP mandate upon which the claimant pays for this case, as it covers only those whose employment were determined via VRP from December 14 to 22, 2015, whereas the claimant's employment was determined on April 30, 2015. Consequently, all the four claims based on this VRP are dismissed. I hold that the fairness and justice of this case demands that the claimant be paid compensation in form of general damages for being declared redundant by the third defendant, contrary to the condition of his employment and in violation of Nigerian laws. I hold that the claimant is entitled to the sum of 200,000 naira only compensation for being so wrongfully declared redundant. And I direct the third defendant, to pay to the claimant the sum of 200,000 naira only compensation for being so declared redundant. I direct that the third defendant pays 100,000 naira cost to the claimant. I direct the third defendant to pay to the claimant the judgment sum of 300,000 naira only within 30 days from today, after which it begins to attract 10% interest rate per annum. For details of this judgment, see a copy of the court judgment in its sister case with suit number NICN/YEN 338/2016. Judgment is entered accordingly.
As the
As the
court
court
pleases.
pleases. We are very grateful, my lord, for the judgment.
My lord, we are grateful for the judgment.
Yes. Number.
The first.
Page number 10. NICN/YEN/268/2 between Emeka Ofwebu and 1 Martin Grayhair. 2 Baker Hughes Incorporated. 3 Baker Hughes Company Limited.
Emeka's case was determined. Employment was determined. Emeka's employment was determined on March 26, 2015. And the cash he's claiming is the sum of 9,839,816 naira 18 kobo. All other claims are the same. Findings. The claimant's contract of employment is at page 802, pages 802 to 817 of the record. On it, his employer is the third defendant before the court. The VRP mandate document is at pages 724 to 726 of the record. And his letter of determination is the letter of determination of employment of the claimant titled notice of redundancy listed as number 8 on his amended list of documents is not before the court. Therefore, the court is not sure that this claimant's employment was declared redundant by the third defendant in the instant case. Court judgment. I hold that the claimant's employer is the third defendant before the court. I hold that the defendant cannot plead estoppel. Number 3, I hold that the claimant failed to satisfy the court that his employment was determined by notification of redundancy as claimed. And consequently, number 4, I hold that his 8 claims are as endorsed on the complaint based on the alleged wrongful determination of his employment by the third defendant are not claimable and they are accordingly dismissed. Judgment is entered accordingly and I make no orders to cost.
We are grateful, my lord. We are grateful for the well-considered judgment.
Yeah. Oh, give me the file. Give me the file. That's what suit number is that?
268.
268, right? Okay. I've not finished. Oh. Rahabula. Don't worry, don't. Yeah. Next. Next.
Number 11 on the cost list.
What happened to you?
She that's great. It's like the phone wanted to go,
phone
so
is
she wants to
Whose phone?
wants to lock, so she wants to get to it. I think.
Yes, go.
Number 11 on the cost list. Suit number NICN/YEN/279/2016 between Michelle Ejadike and 1 Martin Grayhead, 2 Becker Hughes Incorporated, 3 Becker Hughes Company Limited.
Where is this one? Page 4. Sounds page 3. Okay. Okay, where is the page? This is page 3. 3 pages. So 1, 2, 3. You understand? Just 4. Mistake here. Okay. The Michelle Ejidike, the date of determination of his appointment is March 15, 2016, and he's claiming 27,636,869 naira 67 kobo. Findings. The claimant did not file any list of documents he is relying on. The claimant's contract of employment is at pages 162 to 168 of the court record, and his employer is the third defendant before the court. The letter of determination of the claimant employment titled this notice of redundancy is at page 638 of the court record. Court decision. The claimant, I hold that the claimant employer is the third defendant before the court. 2, I hold that the defendant cannot plead the estoppel. Number 3, I declare that the determination of the claimant's employment. Can you hear me, please?
Yes, my lord.
Yes,
my lord, we can hear you, my lord.
Okay.
Yes, my lord, I can hear you.
Number 3, I declare that the determination of the claimant's employment by declaration of redundancy is wrongful, as it was done contrary to his terms of employment and in violation of the provisions of the laws of Nigeria. Number 4, I hold that the agreement in VRP mandate upon which the claimant base for his claim is not before the court. Consequently, all the 4 claims, that's the 3rd, 4th, 5th, and 6th reliefs, are dismissed I hold that the fairness and justice of this case demand that the claimant be paid compensation in form of general damages for being declared redundant by the third defendant contrary to the conditions of his employment and in violation of the laws of Nigeria. 7, I hold that the claimant is entitled to 300,000 naira compensation for being so declared redundant. And 4, I hereby direct the third defendant to pay the sum of 300,000 naira only compensation to the claimant for being so declared redundant. Number 9, I direct the third defendant to pay the judgment sum of 300,000 naira to the claimant within 30 days, after which it begins to attract 10% interest rate per annum until it is settled. For detailed reasoning of this judgment, see a copy of the court judgment on its CISA case with suit number NICN YEN 338/2016. Judgment is entered accordingly, and I make no order as to cost.
As the court pleases. I'm most grateful, my
Hello,
lord,
we're
for the
grateful for
judgment.
the judgment.
Give me the proceeding file of that case. That's that one is what now? The one I just finished.
Chair,
279.
Okay, 279. Like that. Next.
case number 12. NICN/YEN/28 2/2016 between Aneke Daniel Odium and 1 Martin Grigel, 2 Baker Hughes Incorporated, 3 Baker Hughes Company Limited.
Daniel's employment was determined on March 26, 2015, and is claiming the sum of 6,227,937 naira 12 kobo. All other claims are the same. Findings. The claimant's contract of employment is at page 560 to 573 of the record. On it, the claimant employer is the third defendant before the court. The VRP mandate is at page 586 to 588 of the record. And then the letter of determination of his employment is at page 589 of the record. Court decision, I hold that the claimant employer is the third defendant before the court. I hold that the defendant cannot plead estoppel. 3, I declare that the determination of the claimant's employment by notification of redundancy is wrongful, as it was done contrary to his terms of employment and in violation of the provisions of the laws of Nigeria. 4, I hold that the VRP mandate upon which the claimant based 4 of his claims is not relevant to these claims because his employment was determined on March 26, 2015, whereas the agreement in question was effective from December 14 to December 22, 2015 only. It means that the agreement had not been generated when the claimant employment was determined. Consequently, I hold that all the based on that document are dismissed. Number 6, I hold that fairness and justice of this case demand that the claimant be paid compensation in form of general damages for being declared redundant by the third defendant, contrary to his terms of employment. And in violation of the laws of Nigeria. Number 7, I further hold that the claimant is entitled to 400,000 naira compensation for being so wrongfully declared. I hereby direct that the third defendant be paid. I hereby direct the third defendant to pay to the claimant the sum of 400,000 naira compensation for being so declared redundant. I direct the third defendant to pay 100,000 naira cost to the claimant. I direct that the third defendant is to pay the judgment sum totaling 500,000 naira cost to the claimant within 30 days from today, after which it will begin to attract 10% interest per annum until it is finally settled. See for detailed reasoning of this judgment, see a copy of the court judgment on its sister case with suit number NICN 338 NICNYEN 338/2016.
As the court pleases, my lord, we are grateful for the judgment.
As the court pleases, we are grateful for the judgment.
How much is it? Okay. Next.
Case number 13. NIC/YN/286/2016 between Bombs Gloria and 1 Martin Grayhair, 2 Baker Hughes Incorporated, 3 Baker Hughes Company Limited.
Okay. Gloria's employment was determined on January 31, 2016, and she is claiming 16,155,826.25 naira 3 kobo. Findings: the claimant did not file an amended list of documents she is relying on, but our contract of employment is at page 661 to 673. On it, the claimant's employer is the third defendant. The VRP mandate upon which she's basing her claims, she's basing some of her claims. It's not before the court. The letter of determination of the claimant employment is at page 621 of the record. Court decision. On the whole, I hold that the claimant employer is the third defendant in this case. I hold that the defendant cannot plead estoppel. I declare that the determination of the claimant employment is wrongful, as it was done contrary to her. I think Gloria is a she, right?
Yes, ma'am.
Contrary to our employment, to the terms of our employment, and in violation of the laws of Nigeria. I hold that the VRP mandate upon which is basing four of our claims is not before the court. The court cannot verify, so all the four claims on this are dismissed. I hold that the fairness and justice of this case demands that the claimant be paid compensation in form of general damages for being declared redundant by the third defendant. I further hold that the claimant is entitled to the sum of 400,000 naira compensation And I hereby direct the claimant, the third defendant, to pay to the claimant the sum of 400,000 naira compensation for being so declared redundant. I direct the third defendant to pay 100,000 naira cost to the claimant. That's the third defendant to pay to the claimant. I direct that the third defendant is to pay the judgment sum totaling 500,000 naira cost to the claimant within 30 days, after which it begins to attract 10% interest per annum until it is settled. For detailed reasoning on this judgment, see a copy of the court judgment on its sister case number 338/2016. Judgment is centered accordingly.
As the
As the
court
court
pleases.
pleases.
My lord, we
I'm
are
more
grateful.
grateful, my lord.
What's that now? Yes.
Case number 13. NICM/YEN/296/2016 between Samuel Egodo and Martin Greyhead, 2 Baker Hughes Company Limited.
Switch this thing on. Off. Centering my chest. The claimant employment was determined on April 26, 2016. Is it April or 20? Check on where is the file? Just look at the page. Contract of 560. Wait. It's not down. It's 590. Find the 90. What date is that? See now. April 29. April 29. April 29 what?
Maybe 16.
Okay. So his employment, Samuel Igodo, right?
Yes, ma'am.
Samuel Igodo's employment was determined on April 29, 2016, and is claiming the sum of 59,620,795 naira 56 kobo. Okay, I go to findings. The claimant's amended list of documents is at page 528 of the record. His contract of employment is at pages 560 to 574. On it, the claimant employer is Western Atlas International Nigerian Limited. It means that the claimant's employer is not a party to this case. The VRP mandate is at page 587 to 589 of the record. The letter of determination of the claimant's employment, titled Notice of Notification of Redundancy, is listed as number 8 on the list of documents, and a copy of it is at page 590 of the court record. On this letter, his employment was declared redundant with effect from, it was declared redundant, however, by the third defendant. On the whole, I hold that the claimant's employer was Western Atlas International Nigerian Limited and not the third defendant. I hold that the defendant cannot plead the estoppel. I declare that the determination of the claimant's employment by notification of redundancy by the third defendant is wrongful. Firstly, because the third defendant was not his employer. Again, it was done contrary to the claimant's terms and conditions, terms of employment, and a violation of the laws of Nigeria. I hold that the VRP mandate is not relevant. It's not relevant to these claims because his employment was determined on April 29, 2016, whereas the agreement in question was effective from December 14 to 22, 2015 only. It means that the application of the said agreement has already expired. When the claimant's employment was determined. Consequently, all those 4 claims are dismissed. I hold that the fairness and justice of this case demand that the claimant be paid compensation in form of general damages for being declared redundant by the third defendant. Contrary to the condition of his employment and in violation of Nigerian law, the laws of Nigeria. 7, I hold on this court that the claimant is entitled to 400,000 naira only compensation for being wrongfully declared redundant by the third defendant. 8, I hereby direct the third defendant to pay to the claimant the sum of 400,000 naira 400,000 naira only compensation for wrongful declaration of redundancy. And 9, I direct the third defendant to pay to the claimant the sum of 200,000 naira cost. I direct the third defendant to pay I direct that the third defendant is to pay this judgment sum totaling 600,000 naira within 30 days from today, after which it begins to attract interest of 10% per annum until it is liquidated.
I'm sorry, man.
For
I think there
details,
seems to be a
see
mix
the
up, my
sister
lord.
case with NIC. Which one?
My lord, this particular
Which one is that?
because this one that my lord is reading, you've heard above that the third defendant was not the employer. I think there is a mix
But the third defendant determined the employment. The third defendant determined the employment, gave him, signed the letter of notification of redundancy.
As the court pleases, that's what
As
I
the court
heard.
pleases.
Yes, that's what happened. For detailed reasoning of this judgment, see a copy of the court's judgment on his sister case with suit number NIC NYN 338/2016. Judgment is entered accordingly.
As the court pleases. My lord, we're grateful.
As the court pleases. We are grateful for the judgment.
I'm really very tired though.
I'm sorry, madam.
I put on the AC. How much is this one? That's a good one. Yes, call the next case.
Case number 15, madam. NICN /YN/299/2016 between Ajego Eberechi and Martin Grehe, 2, Baker Hills Incorporated, 3, Baker Hills Company Limited.
What do you call the name?
Ajego Eberechi.
Okay, well, 15, right?
Yes, madam.
This one's employment was determined on April 29, 2016, and is claiming 45,022,161 naira 31 kobo. Findings: the claimant's amended list of document is at pages 478 to 479 of the record. His contract of employment is at pages 510 to 523 On it, the claimant's employer is the third defendant before the court. The VRP mandate is at page 535 to 536 of the record. The letter of determination is at page 537 of the record. Court decision. I hold that the claimant's employer was the third defendant. I hold that the defendant cannot plead estoppel. I declare that the determination of the claimant's employment by the third defendant is wrongful because it was done contrary to the terms of employment and the laws of Nigeria. I hold that the VRP mandate agreement upon which this claim is not relevant to these claims because his employment was determined on April 29, 2016, whereas the agreement in question was effective from December 14 to 22, 2015 only. It means that the said agreement had already expired. It can no longer be enforced when the claimant's employment was determined. Consequently, all the 4 claims based on it are dismissed. Number 6, I hold that the fairness and justice of this case demand that the claimant be paid compensation in form of general damages for being declared redundant by the third defendant. I hold on this court that the claimant is entitled to the sum of 400,000 naira only compensation for being so declared redundant by the third defendant. I direct the third defendant to pay to the claimant the sum of 400,000 naira only, 400,000 naira only compensation for wrongful declaration or for being wrongfully declared redundant. I direct the third defendant to pay to the claimant the sum of 200,000 naira as cost. I direct, just hold on. I direct that the third defendant is to pay the judgment sum of 600,000 to the claimant within 30 days from today, after which it begins to attract 10% interest until it is settled. For the reasoning on this case, see a copy of the judgment on its sister case suit number. This judgment is entered accordingly.
As the court pleases, my lord, we're grateful for the judgment. Fine.
How much?
600.
Give me the judgment. Give me the judgment. Some blemish, you people don't listen. 600. Yeah.
Case number 16. NIC/225/2016 between Anthony Akboibo Hills Incorporated, 3 Baker Hills Company Limited.
Anthony's employment was determined on February 6, 2015, and is claiming 5,264,705 naira 26 kobo. Findings. The claimant's amended list of documents is at page 524. Pages 524 to 525 of the record. His contract of employment is at page 558 to 570 of the record. On it, the claimant's employer is BJ Services Nigeria Company Nigeria Limited. This means that the claimant's employer is not a party in this case. The MRP mandate is at page 582 to 584 of the record. The claimant letter of determination of employment listed as number 8 on the court record, and it is at page 585 of the record. On this letter, his employment was declared redundant with effect from February 6, 2015 by BJ Services Company Nigeria Limited. On the whole, I hold that the claimant employer BJ Services Company Nigeria Limited, and that, on the whole, I hold that the claimant employer was BJ Services Company Nigeria Limited, and that it was not a defendant before the court. Services is not a defendant. In this case, I hold that the defendant cannot plead estoppel. I declare that the determination of the claimant's employment by BJ Services Nigeria Limited is wrongful. I hold that the VRP mandate upon which the claimant based 4 of his claims are not applicable to his case. So all the 4 claims, 3, 4, 5, and 6 are dismissed. I hold that the fairness and justice of this case demand that the claimant be paid compensation in form of general damages for being declared redundant by BJ Services Nigeria Limited, who determined the contract of employment as well. However, since the claimant did not sue BJ Services Company Nigeria Limited, who employed him and who also determined his services, there is no defendant that the court can direct to pay him any compensation for wrongfully declaring him redundant. In the circumstance, this case is accordingly dismissed. For detailed reasoning of this judgment, see the sister case with suit number NIC/NYEN 338/2016. Judgment is entered accordingly. And I make no order as to cost.
As the court pleases.
The court pleases.
We are grateful, my lord, for
As the court pleases, my lord, we are grateful for the judgment.
What number is it? 16? No, take it to 20. I said AC.
Okay, 25, my lord, sorry.
Take it to 26.7 means APR. Okay, that's the end of the court judgments. So as soon as the court resumes, counsel can come and pick copies of the judgments in the court.
All
As
right,
the court
Mama.
pleases.
As the court
Can
pleases.
you? Okay.
We
Okay.
commend the court for the time, for the painstaking delivery of the judgment. I'm grateful, my lord.
You're welcome.
My Lord, we commend the court for the judgments. We are grateful, my Lord.
Thank you, Ben. Thank you. Okay. Thanks, and God bless you all.
Amen. And you too.
Bless it to you, my Lord. Amen.
Bye.
Okay. Okay. Bye. Arabe, yeah, come and disconnect me. Thank God. My neck.
Sorry, very 4 hours.